We enjoy doing our cases. After 6 months, we're like, what's next? Because we've seen the issues, we've thought about them. We like to know what's going on to the next thing. So I think I can speak a lot about it. Let me hand the floor back to you.
So this is a cost comparison, which I think is really helpful again when I speak about proportional arbitration efficiency. As Indian practitioners, we do understand it with a different lens as well. So since the time, if you all recollect, 29A has come into force, there has been in the real sense a lot of pressure on
ऑडियो
arbitrators
पकड़
as
रहा है,
well.
लाइव तो हो गया बट ऑडियो वीडियो
I'm sure everybody on the panel will
इसका
agree
वेबकैम ही
that
लगा
they've
देते
all
हैं यार।
been party to arbitrations.
बट इसका वेबकैम लगा
By
दो,
panels,
वीडियो
of
चल
course,
रहा
which have gone on for 11 years, 12 years, prior to 29A. And I think what 29A has done has really shifted the game, and it has made the arbitrators aware of those developments. Similarly, I would say that the rules also sort of push that agenda, and they give you something called proportionate arbitration. This gives clients predictability, and more importantly, they give them a sense of how much everything is going to cost and how many days I'm going to be engaged in this dispute. Anything else to know?
सॉरी इससे आ रहा है ऑडियो कहाँ से आ रहा है, मुझे लग रहा है ऑडियो भी इसका पकड़ रहा है।
The only point of this slide, we can come back to this
इसी का पकड़ रहा है
to
ना।
say we've thought about the whole process from the contract making stage into the enforcement
कैमरा
stage.
कनेक्ट ही नहीं हो रहा।
Really what this comes down to is allowing the end users, who are the ones who choose whether to go to arbitration in the first place, to allow them predictability, because that's what allows them to run their businesses, to have a conversation with the CFOs to say, this is your issue, this is your issue. It allows them as well leverage in negotiation to say, this is how far I'll push it, and this is how long I'll push it. Enough from me. Maybe we have the perspective of the house council since we've been talking about that for quite a bit.
I invite for sure. Nidhi, can we please have you here on the podium? We are all talking from here today because we are also being live streamed for the benefit of the participants who couldn't attend in person. Please welcome Nidhi on the panel. We are going to be now really looking at who we are writing this award for. Because at the end of the day, like I said, parties do not care. They do not care whether your pleadings were fantastic. They do not care how great your arguments were. But at the end of the day, they care what my award looks like. Is it going to get me what I actually went in to get? And can I enforce it? And I think Nidhi gives great perspective because she represents most of those funds.
On a lighter note, actually, the HR cares, because if my contract is not drafted well enough, I don't get the appraisal well next year. So, hi everyone, good afternoon. I'm glad to have all of you here. Thanks, Aface, for organizing this and having me here. This country totally needs business in every possible way. I always say this in India, right from the Panwala to Mr. Ambani, everyone's doing business. So everyone has the power to decide what they want, what they don't want. Now, when it comes to business, I think that's the core. That's the core of this country for everything that we do. We care about the pleadings. We care about everything. Like I was, just mentioning to Achal. Of course, we as in-house counsels have to take complete accountability for that. We have to ensure that everything, all the details go in exactly the way it is supposed to be. But when the arbitration, when we reach at a stage when we have to decide if you want to take in the arbitration or if you want to sit across the table and settle the matter, I think what is important is what is my risk exposure, what is the award, and what are the probable outcomes when the award will come through. Now, I think the most important point that we want to keep in mind is the simplicity in the language that we are referring to. The outcome for my business, while I may face financial exposure while I'm doing work, another important point is what's happening to the work and the transaction that was ongoing at that point in time. Do I have to stop work because there's an interim order against me in that, and final award says that do I have to go to an appeal? Am I stuck with interpretation issues right there? So I think simplicity is very important. When I say simplicity, I mean non-ambiguity mainly. Keeping in mind the fact that most of the readers and implementers of the award are not actual lawyers is extremely, extremely important. we want to know the citations as lawyers. We want to know what is the legal point it's leading through. And so be it, because if we didn't have that, then we wouldn't have clarity. If everything was going to go to rest judicata, then I don't think we would have, landmark judgments like the Malcolm judgment, etc. It is important, but at the same time, let's just ensure that it exactly caters to what is required. We do not mention, unless it is important to mention the entire case history again over here, because they just go like, come to the, when I'm talking to my promoter, they're like, please come to the point. What is it? I don't want to know all this. They're not interested in writing the 30 pages award that you've written, with all due respect to all the arbitrators here. So I think that's something we really need to keep in mind when we're going about that.
Thank you. I have a list of questions for you, but in the interest of time, can I maybe ask you about AI? Do you think it will support what we're trying to achieve or undermine what you're looking for?
I think it will definitely help. But I think what is also important is AI is fair information, the way it needs to be brought out as well. That's why if anyone's been following the news, you see the ex-CEO of Twitter has been working towards how AI, the model in the countries where AI, there are softwares now to feed information in AI, so that it gives you the information that you actually want. Today when I just write, if I'm writing India particularly saying what's the, let's say it's a fresher, let's say it's someone who's a layman, forget a fresher, forget a lawyer, let's say it's a layman who's writing what is the outcome of an arbitration and leave it at that. If he's not writing the word India, does he get the information for that particular jurisdiction? So, then that can be misleading because they do not know exactly what it's going to refer to. And I'm referring to a layman because they are at the end of the day the parties that we're referring to. He may not be, at that point your party, but eventually he will be, and these are the people who make a lot of ruckus when it's not required. So I think AI is very helpful. It helps, stream down and help us. It's again another addition that we have to other tools in computers where you have a lot of information. It streamlines your work. You can then focus mainly on the crux of the work and the main crux and the meaty part of the award, not just the facts that you have to keep on mentioning. It will help you streamline what you want to mention, what you don't want to mention. But I think that set of information also is something we need to ensure is responsibly fed into AI before you take it onto your awards as well.
The camera, because of the Wi-Fi, it's not able to do that. मैंने अपने hotspot से भी करा, audio हो रहा है. Video में issue हो रहा है. Audio जा रहा है, but video, I'm trying. Just give me 5-10 minutes.
When the copy paste judgment is going to come, but we have mentioned it. And I think this is a great segue to our next section, which is what exactly should be a general structure of the award. What is, what all has to be included in it? How do you draft it as an arbitrator? How do you approach it once the pleadings are complete? You have the entire document set in front of you. And they are already here, but Vijay and Shruti are going to guide us through this very, very important segment. So I'll welcome you.
Good evening, everyone. Thank you so much for having us here. Thank you. So if we can move on to the next slide, what Shruti and I will be covering with the structure outline of an award. Next slide, please. And before we go into the structure of the award, we thought it might be helpful to just remind ourselves again what exactly an award is and the various types of awards that are out there. I think fundamental distinction to bear in mind is the one between orders and awards. In short, an award is one which disposes of finally the issues that it addresses, whereas orders are meant to be interim in nature and to drive forward the procedure. And I think that Delos rules makes it clear that orders can be amended in the course of an arbitration. So I think with just that in place, we will dive into the various types of awards that could be issued in the course of an arbitration proceedings. And just to say, all of these have actually been clearly expressed in Article 13 of the Delos as well. So Shruti, on the final award.
Yes, the final award, as we all know, is what everyone looks forward to or not at the end of the day. It resolves all factual disputes, it applies the law to the facts, and it ultimately provides you a consequence of or outcome
आप ऐसा करो, record करो.
Very different, of course, from when you get to know.
So the interim award
Record करो.
would be one that is issued before the final award. There is some discussion and debate perhaps over the semantics of whether you call it an interim award or partial award. But the short point is that it's not going to be the final decision that's issued by the arbitrator. And now to the partial award.
The partial award, of course, as you all may know, we don't see this as much in many domestic arbitrations, but I have experienced this in construction and oil and gas. Is where the award is partial, but it does finally determine a particular issue required. It depends on the context of the case, of course, but it's not so often used, but it's only in certain sectors, let's say.
Yeah, and I'd say that it's very much driven by the partners as well. So one example of a partial award might be one jurisdiction. It is decided as a premier issue whether the parties or the tribunal has jurisdiction over this particular dispute. The decision will usually contain a partial award. And of course, if the tribunal decides that they do not have jurisdiction, then in that sense, it becomes the final award.
Which takes us, of course, to consent awards. Consent awards will look very different from a final award in many sense because it is arising out of a settlement of sorts between the parties. So, as you can imagine, a consent award reads very differently from a final award in many sense.
Yeah, as an arbitrator, I'm obviously also very pleased that the parties managed to settle the issues by the dispute by themselves. But as the Delos rules does contemplate, it is possible for there to be a consent.
आप record करते रहो, मैं देख रहा हूँ.
Advantage that is that you can then utilize the New York Convention for reinforcement thereafter. Going back, I think, a bit to the default award, just to cater for parties who, for whatever reason, do not wish to participate, and I think it would be 12.4 that provides that the tribunal may proceed with arbitration nonetheless, even if the parties do not participate in the proceedings.
And finally, a default award, award where a party does not participate, we were discussing with some of the panelists earlier, is often tougher to write than to write an award where parties have in fact participated. Because you have to be so conscious that you're not just, letting one party that's representing itself have a free ride in many senses.
Yeah, so a default award is very different from default action. Termination award, this is when, for whatever reason, the tribunal finds that it can come to the end of the proceedings and dispose of the issues in the final award. The termination award seeks to terminate the arbitration. Again, this is clearly contemplated within the Delos rules, consistent with other institutional rules, which reserves the power for the tribunal and the institution to call an end to proceedings, primarily and usually because when the parties fail to pay the cost of arbitration or the defaults that are required.
And an additional award, lastly, just for a broad sense, can be an award which follows maybe an issue which was not sufficiently determined, parties needed additional interpretation. So very often that finds itself, or something that got missed out can be found in an additional award.
Now we move on to the next slide, the structure and outline. Again, this is not meant to be overly restrictive, perhaps more as a guide or reference perhaps a bit simplistic, the title page, which I think a lot of us tend to skip over, but nonetheless is extremely important. This sets the baseline and helps facilitate the enforcement of what thereafter is necessary. So the parties clearly stated, and it's helpful to name that as the claimant and the respondent, so thereafter it can be referred to in shorthand. The applicable procedural law. In this case, I've used the example of the International Arbitration Act of Singapore, and the legal and procedural rules. So here we've taken an example of the Delos rules of arbitration. All these again, it's on the arbitrators to check that they are entirely accurate. The information, other information that would be included would be the award type of award. So you can see here on the screen the type of award. But for example, it's a partial award, an interim award, number 1, 2, 3, 4, 5, and so on. Let's see. So the date and the details of the tribunal as well, seat of arbitration.
The parties, of course, it seems like a very simple thing that people would record the parties, right? But very often the incorporation, where the parties are incorporated is a very relevant fact because as you can imagine that would determine in our example, whether it is a domestic arbitration or an international arbitration, what rules will apply. For example, in a time limit to 29 years per hour Act apply to domestic arbitration. So it is relevant where the parties are incorporated, and it's very important to record that.
So the identity of the parties as well as counsel in international commercial arbitration is very, it's common practice for you to list the name of counsel in the cases as well. A slight issue or complication arising from this would be if there's funding arrangements. So the Delos rules does require parties' legal representatives to inform the tribunal there's a funding arrangement and the persons who they're taking instructions from. I think for good order as an arbitrator, I would record such information within the parties' information as well.
Yes, particularly since the recent amendments to the IBA guidelines also now require disclosures about third-party funding. It's simply so that everyone has a sense of who actually has an interest in the outcome of this arbitration.
And the arbitral tribunal is a sole arbitrator. It's quite straightforward. It's details such as the dates of appointment, when the person is appointed by the institution, the letter of appointment, etc. When it's a three-member tribunal, then we want to the details of the party appointed arbitrators as well as the presiding arbitrator. The next slide, please.
So a lot of what Region was just talking about finds itself in the procedural history. Very often, it's important that every award have a procedural history. While this seems pedantic in many ways that you're just recording dates and events of things that actually happen, it's critical because it does lead to avoiding challenges subsequently. So for example, where the arbitration was recorded as consent of parties under the Delos rules, subsequently in a challenge, and assuming this is a post facto consent of parties, subsequently in a setting aside, this should not be an issue. So therefore the procedural history is a very important part in the arbitration award.
Yes, and just now you mentioned the default award as a non-participating party. Again, those kind of matters you know the procedural history. As the arbitrator, usually I would take pains to record the measures I've taken to ensure that the non-participating party is adequately notified of the arbitration to avoid them later at the enforcement stage walking out in court and claiming that they did not pass the notice. The arbitration agreement and jurisdiction, these would be very peculiar to arbitration laws, of course. The power of the court is drawn from the state, whereas for arbitrators and arbitral tribunals, we don't have that luxury. So we have to be very careful about setting up the foundation of our authority and establishing the arbitral proceedings. You could have circumstances where, for example, the law of the seat is not clearly stated in the contract or in the law of the arbitration agreement. In those situations, if the parties can independently agree, for example, during the first case management conference, it's helpful to record that in the award as well.
And like we already discussed, administering institutions, critical to have it recorded in the arbitral award. Just to give you an example, there's an institution which rendered an award in a case of ours, and the rules allowed for a certain authority of the institution to make a determination as to challenges to an arbitrator. The opposite side did bring such a challenge, and fortunately for us, such authority was conflicted from passing any sort of view in our case because there was a conflict situation. And so automatically somebody else within that institution had to take that decision because someone in the institution has to decide. This of course became subject of ground for challenge in section 34 and is still pending of course, but needless to say the fact that the rules were clearly drafted and parties had agreed to those rules made it a lot easier for us to defend a setting aside request on that award.
So I think one other point to add on the arbitration and the agreement and jurisdiction, if the parties can agree whether the contract or otherwise is wonderful, if they can't, then you take out as an arbitrator, you do have to write down your reasons for concluding that seek a certain jurisdiction.
I think while we are of course dealing with the parties' position and reasoning, we're not going to go too much into it, but the award should of course recognize what exactly the parties require. If there was a counterclaim, what the respondent also sought for in the proceeding.
The factual background, I think, is a way of the arbitrator demonstrating that they have clearly followed the proceedings. One of the easiest methods would be hopefully to be able to cut and paste the parties' submissions, but if they are not of the kind of quality or with the kind of conciseness and
both sides argue what issues should be framed. It's a lot broader, but the importance of that one is very important.
Yes, I actually quite like the idea of having a hearing just to determine the issues because it is that critical. In international commercial arbitration, it's more common for it to be submitted by the parties, and then the tribunal goes away and sometimes put together their own list of issues. Obviously, we would like the parties to agree, and sometimes they agree to a list of issues that might not really make sense, and that's when there needs to be intervention. But the issues to be decided is key because it crystallizes the points which you think need to be answered for there to be a final and enforceable reward. I think at this point, one thing, be careful not to exceed jurisdiction. So if the issues have been agreed, you can't just put in anyone just because in the course of proceedings we feel that it's correct. But if we do feel strongly about it, then something to be ventilated to the parties. In relation to the Delos rules, I also note that it does state that the issues to be determined should be set out in the notice of arbitration, defense, etc. In short, the statements need to be submitted by the parties.
Yes, absolutely. Even for us, from a domestic perspective, one of the grounds for setting aside a domestic award is where either an issue that was decided and the issue has not been determined, or has there been over-determined issue. So it's a very critical process.
I think we won't spend too much time. This is the meat of the analysis and reasoning because we're going to hear a lot from Leah, who I think has much better comments to share in relation to that section. I'll just touch briefly on the cost and interest here. It's meant to be usually in the substantive part of the award as well. And I will be touching on more details in that in the money section of our presentation. For the next slide, please, so the dispositive slide.
The dispositive, of course, is what everyone reads first when you receive an award. You come to everything else later. Who's won, who's lost, what do we win on, what do we lose on, and why. Essentially, it is your conclusion section, and Priya and I will be also running a short exercise on this at the towards the end of the session.
And now, deviating from our structure, because this, the next slide, just some general considerations. The first is adverse inferences. It doesn't fit neatly into a structure, but I thought it was worth mentioning because as a tribunal, you might be asked to draw adverse inferences, which can be quite, I think, a tricky thing to do. I think the general rule of thumb would be very careful before you draw an adverse inference. For example, if a witness who has put in a witness statement does not appear at a hearing for cross-examination, does not necessarily mean that it's still safe to draw an adverse inference, in the sense that everything the witness is going to be saying would be necessarily prejudicial to the party who is appearing as a witness for. The safer option might be actually then to decide how much weight you want to place on the person's witness statement.
The joint and several liability for costs, or even otherwise in terms of liability, a very clear set out sort of reason as to why the arbitrator has come to that conclusion, particularly falling back on the relevant law or rules that are being applied to that conclusion.
Yeah, so I think the joint and several liability for costs might be more predominant. For example, you have multiple correspondence. If it's cost, let's say 2 million dollars, and it's not clear which
Connect me,
correspondence will pay how much. It's much better to be clear in terms of the direction because we are joint and several liability and just takes for dissent, in a 3-member tribunal, which is also contemplated under the Delos rules, there might be times when you might feel compelled to put in a dissent. My personal view is that it's helpful to give a dissent only if you think that the issues
उसमें रिकॉर्ड हो रहा है ना
or extremely unbecoming conduct, which should be highlighted and then be further on grounds in relation to the impossibility. But otherwise, unless it's absolutely need to, you might not be impressed with it.
Just in addition to these general points, some basic requirements for us from an India perspective, assigned award. So in terms of our act, we need to have a signed award delivered, and we are seeing currently a challenge where the arbitrator may know to the parties that the award was ready and you must have it collected. The party that obviously lost then collected the award, so they claim you have never received the sign award. So the claim is that when the arbitrator ought to have sent it to me and not asked me to collect it. So the small things like that, there must be a signature on the award. They seem very minor, but they can have huge ramifications subsequently.
For unconscious bias, I think in relation to a two-member tribunal, sort of first concept might be whether party-appointed arbitrators are more prone towards the other party. So I'll just leave that aside as just a potential risk. I would say that for sole arbitrators, there's also that risk in the sense of we're all human, and if we think that a party is behaving uncommonly, does it steer us towards another conclusion within them? So I think the point is it's important to repeatedly stress test your own analysis, and I think we will be able to cover that as well in the reasoning of the award. The last point of the I'm not going to go too much into it. I think it's clear that no one should be feeling
वीडियो डायरेक्टली नहीं जा रहा है बट रिकॉर्ड तो कर रहे हैं इमीडिएटली उसके बाद डालने के लिए सो पैनल रिकॉर्डिंग तो चल ही रहा है
बट लाइव में नहीं आ पाएगा।
लाइव में सिर्फ ऑडियो जा रहा है अनस्टेबल कनेक्शन की वजह से
ऑडियो जा रहा है कंटिन्यू।
ऑडियो जा रहा है आप चेक कर सकते हो ऑडियो तो जा रहा है चल रहा है इट्स कनेक्टेड ये तो चल रहा है तब से
Well, I think this brings us to the end of our section. Thank you very much. Thank you.
In fact, an anecdote that I like to share, Shruti, this is from what you just said. We are in fact briefing Ms. Kapoor on a matter where the tribunal consisted of three people, and one person did not just not sign the award, but sent an award much later than the majority award, once the majority award was delivered. So the minority, or rather the dissent, came in much later, and no signatures, and the reasoning for those signatures being missing was actually put in the majority. So we are before the Delhi High Court. I'm so happy that we are actually discussing this topic, and we briefed Ms. Kapoor on it, and hopefully, yes, fingers crossed, it should be in our favor, but please don't do these mistakes once you are writing these awards, and make sure that you have all those checkpoints in place. And this is a great position, a segue for me to please invite Ms. Kapoor on the dais here to really talk about the nature of the matter, the positions of the parties, and the reasonings. Just before you start, I'd just like to also say this is intended to be an interactive exercise, so I would really request you to please note down all your questions and answers, and we're going to deal with it towards the end of the session. So you will get a chance to also ask those kind of questions. Thank you.
So, since Archana has said it's going to be interactive, I'm going to start with a question. First Nidhi said that look, this award needs to be read by my promoters, and just keep it really simple. Just tell me what it is. What is the award? Don't get into anything. So we could possibly just have an award which has the ultimate decision of the tribunal, which is what we call the dispositive section. If we get away with that, if you think we can get away with that, hands up. No, right? We need reasons for the award. And why do we need reasons for the award? I think firstly, the Act says so, right? Our Arbitration Act, if you just get to the next slide. This is how those facts that stand proved. I have applied X, Y, Z in the contract, or I have applied the law. This is the settled law. I can cite all those cases, although he does not want me to cite those cases, and finally come to a conclusion that this is the reason why I have decided what I have decided. Those are the reasons for the award, right? Now, in every award, you will have many issues. You're not going to have one, right? So if you see the structure that was set out a little earlier, where in the award, I would say just, being A as an arbitrator or B as a counsel sometimes challenging an award, it is much easier to have all the submissions and the positions of the parties set out issue-wise. So the points for determination, all the issues as framed, what you ought to do, but the audience fair award is also the judiciary. Your award needs to be upheld by the court.
And in order for your award to be upheld by the court, it has to stand the test of the Arbitration Act. It has to stand the test of the formal requirements of the arbitration award, which are what set out in Section 31. And it also needs to stand the test of Section 34. How do you ensure that your award stands the test of a Section 34? And as arbitrators, that is the key, right? Of course, the award must be nice to read. The award, must be clear. The language must be nice. It must be, easy on the eyes. But the most important thing for our awards is to stand the test of Section 34. And what makes it stand the test of Section 34 is the reasons. Your reasons must be clear. Your reasons must be concise, and they must not be contradictory. So be very careful when you are drafting your award to ensure that you have set out the reasons very lucidly, very clearly. And also, please make sure that the reasons in one part of the award do not contradict the reasons in the other part of the award. So let's just flip the next slide, since we're just in Section 34. Where does this come from? Where is the fact that one is, of course, you have Section 31, which says set out the reasons. You then have Section 34, which says that if it is contrary to the fundamental policy of India, or just the next slide, please. Or if there's patent illegality, right? These are sort of the two tests that we have to meet. And let's flip the slides. You'll see how the courts have, you can flip, Section 48 will also have a similar test, but a little narrower. So you may get away with unreasonable award sometimes in a foreign award, but you won't get away with an unreasonable award in a domestic award. Unless, of course, there is, as we all know in Section 31, you can dispense with the requirement. Parties can say, look, we don't want reasons in the award, but absent that, you must have reasons in the award. Can we just take this slide? This is uncitral, carry on, which is what ours is based on, and therefore, anywhere in the world, if you have to enforce your award, you should have the reasons. So all the judgments, starting from associate builders, which we all know is really the one judgment we will all go to in Section 34, is that you have to provide reasons for the award. And it says it would be regarded as a patent illegality. So not only are you violating your Section 31, but it is a patent illegality if the reasons for the award are not stated. And these are all just, if we just flip these quickly, but you will see judgment after judgment after judgment, which says that if there are not valid reasons given in the award, it will be set aside for patent illegality. And in fact, just if we can go back to the DMRC slide, DMRC, this order act curative, took the position about evidence not having been considered, right? So when I said when we're looking at reasons in the award, the reasons in the award can't simply be, I thought so, in my view, right? That's not the reason. I have to consider every piece of evidence. So the helpful way to think about it in a slightly structured way when you're writing your awards is claimant leads their evidence, defendants lead their evidence. Consider every piece of evidence that has been led by the claimant. Discuss all of it in your award. Because if you do not discuss that you have considered this evidence, you could leave yourself open to a DMRC situation where it will say, well, you have not considered a vital piece of evidence, and therefore your award is liable to be set aside. So really, and when we say evidence, there will be testamentary evidence, there will be documentary evidence. Look at how, on each issue, what evidence has been led on that issue, what arguments have been made on that evidence, how that evidence proves or does not prove the fact that they're trying to show, and set it out very clearly in your award. So, I mean, that's sort of the broad outline of why it is really important to state reasons in the award. The second aspect which I was touching on was positions of the parties, right? Do I have to set out what is the position of the party? And this has two aspects to it. One is, again, if you see the Arbitration Act, and it says that if the award deals with a dispute not contemplated by or not falling within the terms of submission, or it that contains decisions on matters beyond the scope of submission to arbitration, it is liable to be set aside. So unlike a court where two parties may be making any arguments they want to, and the judge feels, well, actually the reason to decide this case is something completely different, which nobody has argued before me, and I think that's actually the correct argument. A judge has it within them to write a judgment based on what it thinks is right and what, according to it, is finding the truth, so to speak. An arbitrator does not have that attitude. Arbitrators have to confine themselves within the four corners of the submissions that have been made by the parties. And therefore, it's important in your award to record very clearly what is the position of the parties. What are the submissions that have been made by the claimant? What are the submissions that have been made by the defendant? And therefore, this is the position of the parties, and based on these two conflicting positions, this is my decision. On the basis of the evidence, on the basis of the law, on the basis of the contract. But it has to be based on the arguments and the submissions that have been made by the parties. It cannot fall outside the four corners of it, so record the position in your award. I think that's about all I'm going to touch on. I think that's about all I have time to touch on. So we'll come to the more, so there are two important parts of the award, and not just because I'm speaking on both of them. One is the reason, the other is the dispositive part, so we'll come to that later. Thanks.
What this said A plus B equals C. Went to issue 4 and said because A plus B equals C, I am deciding this in this manner. The other side filed a section 33 application, which is, as you all know, for a correction of the award. That award was corrected only restricting to issue 1. So what he did was he forgot that there was an issue 4 that relied completely on issue 1. So A plus B was now not equal to C. But issue 4 said A plus B equals C, and that is why this is my conclusion. And really how it plays out, once these awards are actually issued is very, very interesting, and it all seems really tedious right now, but when it really plays out, it's super, super interesting. With this, I'd really like to call upon stage Lee Jun. Lee Jun, if you could join us. Oh, wait, no, this is Nidhi, it should be, I'm so sorry. So, drafting styles and audiences. Of course, we have 100 people in the room today. As lawyers, all of you have 100 ways of drafting your pleadings. What styles should you adopt as arbitrators? Is there a set format? Is there a distinction between domestic award or an international award? How do I really approach it? I'd love for you guys to please come in and weigh in on this. Lijun and Shruti. Nalin, Aniti and Shruti.
Actually, I don't think there should be a difference in the drafting styles we say for domestic and international. And more, as we see, just in the last 5 years, for example, the way we conduct our domestic arbitrations is becoming pretty much, coming up to the standard of an international arbitration. There's a few peculiarities, but particularly when it comes to a award, why would you expect a difference of standard? You just expect the best award, whether it is domestic, international, seated in India, seated outside. And then when you receive an award as, a party, are you very impressed with big English words in it?
As far as English and not Latin, I'm still better off. So if that was my choice, yes. But again, not the fanciest words which are not easily understood by a layman.
They're easily understood, right?
Yes.
So, like Dia said, it was so important to have your reasoning right as the arbitrator. But what good is having that reasoning sorted in your mind if it's not something that you've been able to communicate in the award? And so I think the first rule of drafting the award really is a simple award. Simpler the better. Simple, of course, does not mean Control C, Control V. That's too simple, and that's going to land you in a whole different kind of soup. It's simple enough for the readers that while we do keep saying that the reader is the party, honestly, I'm writing an award and my reader is the party. It's always the losing party first. Then, because they're the ones who are going to challenge the award. The winning party second, and then the thought of the high court, of course, is always also pervasive every time you're writing an award. But do you feel there should be a difference in maybe more technical awards? Like, for example, if you do a construction arbitration and you have an award, or you've done so much oil and gas, those can be so much more technical, right? Do you see a difference in a pure contract dispute and a more technical dispute in the style of the award?
Well, I think the difference is, and I think this is also one of the beauties of arbitration, is that I'm not going to a judge who may or may not have expertise in that subject. As an arbitrator, in arbitration, as I can choose an arbitrator who comes from the field. More often than not, you appoint an arbitrator who could be an expert in that subject. So a lot of times what they are narrating in their awards is also coming from experience. It's also as good as setting the ground for future events, is prevalent to the practice in that particular sector at that point in time. Having said that, yes, they get a little technical. They can be extremely dry for a lawyer to understand, because they may not have the experience from a technical perspective. And being in-house or being external counsel, what the advantage we have is that we can sit down with the technical team and understand that part. But if it is technical and it is pertaining to that, no problem. Ultimately, your award is still again on the legal point of view. That, if it stays simple, it helps all parties to take care of and maintain that work. I think when it comes to any technical industry, getting into the technicality, because a lot of times, apart from the basic contractual disputes, if there is something that needs to be thrown light upon, it is these arbitrators / experts who can add value to it. And I think that's one thing I kind of appreciate being clarified in the award as well.
But you're right, who your tribunal is has so much to do with what your award looks like. If you have a 3-member tribunal which is presided by a technical member, that award reads very differently than a 3-member tribunal where one may be a technical member but the presiding is still an advocate or a retired judge so those awards read very differently, simply because the technical person who's writing an award tends to assume that everyone else understands what they're talking about, which is very often not the case. What can you do about that?
Same goes for lawyer and technical. I've actually had arbitrations where one of my arbitrator was a technical expert and the other two were lawyers. One being a retired judge, as coincidence would have it. And it wasn't always easy to keep either of them interested if you were talking about subjects with, while arguments which were not pertaining to technical / legal, depending on who's listening to it. So I think, again, ensuring that you're dealing and referring this, keeping it simple, keeping it crisp, as Dia also said it, ambiguity and keeping, we have these awards which we read paragraph 2 with paragraph 4 with paragraph 8, and by the time you're like, okay, what am I reading? And they're like, you give it to a promoter because they want to read it, and believe you me, they have a lot more knowledge and insight on law than a lot of practicing lawyers would have. Trust me, they are very well versed with their law. So they will say that, what does this mean? Again, another point, I'm sorry I'm taking an extra minute here, is that we're forgetting the flavor or the reason why arbitration practices came into existence. It was to ease the work of the courts. Here, half the time if you're going to the court because of interpretation issues, how are you easing the court's work? So it's these basic things you're keeping in mind. And I was just discussing with Nijun before our session started that more often than not, if I was an enriched party, with resources, I will find the best lawyer. And if there were two parties to the matter, right? One being enriched with resources, one with limited resources, I will find every loophole in the award to have it dragged for years and years if that award is not in my favor. Now, if you flip that, the party with limited resources, while we not have the clarification, will say, let's just let go of this thing because I don't have the time and money to keep spending on this. So it ultimately boils down to money. But in the entire process, who's losing out is again us, not just as lawyers, but as humans who might have to go through this cycle again with other set of parties, etc. So I think when you set the ground rule clear the first time, you do a lot of good for everybody who's getting impacted with that judgment or the award.
Yeah, that makes a lot of sense. So broadly, I think what we're saying is everyone can have their own drafting styles as an arbitrator. Keep it simple is the first ground rule. Keep it short, as crisp as possible. Sometimes arbitrators feel the need to over-reason. That could also lead to potential issues where then in that over-reasoning you end up contradicting yourself. Of course, you're writing an award with the mindset of enforcement, and you must remember that the enforcement is not just in your jurisdiction where the seat is, but it could potentially be several other jurisdictions, so that's something to be kept in mind. Small things like, for example, humor or sarcasm when you're drafting an award. Often the way you're thinking it, it's like text messaging. Sometimes the way you think it and the way it's delivered can be a world of difference. So it's similar to that, in an award. If you think you're trying to be funny, it may not translate very well, to a third person actually doing it. So yes, broadly, I mean, just keep it simple, cover the most relevant aspects right from the structure that we've seen through the day. And yeah, that's about it.
On a lighter note, I have a question for Shruti. Have you ever seen a party raising objection to any of the humors or the arbitrator story, and then taking objections or?
I have raised an objection to an award where I don't think, of course, the arbitrator meant it in that way, but I said just look, he was biased from the start.
A flavor of bite.
I know we are running short on time, but I would like to invite Liz are here, which is the money sections of the award, and what really you have to focus on when you're writing that particular section. More importantly, it's really relevant to the Indian context, because as you would notice, a lot of the awards that we come across would not have very detailed money sections. So Vishwan, if you could please help us out with this. Thanks.
Thank you. So as Ancha mentioned, we start the arbitration for the revenue, right? Next slide, please. So I'll just talk about the first revenue, first damages. I think that all of us as experienced practitioners would have a lot of money, would be able to draft that part in our pleadings or submissions really. So in that sense, it's not all that different, the precision. So for example, saying I find that the respondent has breached the contract and calculate the damages as euros $1 million is not going to be sufficiently clear in the context of an arbitration award. You literally need to direct the parties. In this case, it's much better to say respondent is to pay the claimant immediately the sum of euros $1 million. 1 million euros. Now, somewhat associated with that, one of the considerations when it comes to arbitrator, it's within your discretion to decide whether it should be 100, 90, or 80%. Now, party costs would be those legal fees and expenses for their lawyers, or their experts, or their witnesses, and the internal cost of the party. In some international arbitrations, it is quite common for the parties themselves to pay their internal costs. So, for example, whichever director or somebody on the business team who has been devoting 200 hours to it, and they charge the other side accordingly as part of their costs. Again, cost over based on the principle of cost over the event. Usually the successful party should be given the awards, but the question of percentage is again up to the tribunal. In international arbitration, it's common for the tribunal to look at the cost schedules for both parties to decide, for example, so if one party's legal costs ended up being 200,000 versus the other side who has racked up $1 million in fees, that could mean that a reasonable amount of cost might be somewhere in between. Again, very much within the discretion as the tribunal. Now, still staying on costs, one point to consider is the time for addressing costs. I think the golden rule is that for a tribunal, you can't issue an award cost until you have heard the parties on it. So it's very important to hear what the parties have to submit on the issue of costs. The question is, do you do it before you have decided on substantive issues, i.e. who is the losing or winning party, or do it after? Doing it before would mean that the tribunal would order the parties to put in their closing submissions as a cost schedule and brief submissions as to what the cost decision should be. The other way of doing it would be after the final award, or rather, the award on the main issues have been published, and you know who the losing or winning party is, and the parties would then submit how much is the cost should be in favor of each of them. I think that would mean that the winning party might be incentivized to put in costs that you might expect to be higher than if it was before the decision. But again, it's up to the tribunal to decide. Offers to settle, I think most of us in this room will be familiar with the concept. I think the short point is that this is also something to be considered in arbitration. The Delos rules again also includes offers to settle as one of the considerations for the tribunal in terms of deciding how much cost to award. Now on third-party funding, as Shruti has earlier mentioned, under some rules it's important to notify the tribunal if there is any third-party funders. The question then is, can the tribunal or should the tribunal order the losing party to bear the cost of the premium paid to the funder? There's some case law on this, and there are situations where the successful party could claim the premium paid to the funder, but that's usually where there is egregious conduct. I think this is one area that we need to be very careful about, and I think it's more commonly found that perhaps the premium paid to the funder will not be one that has been borne by the losing party. Moving on to contingency fees. Very briefly, for example, a lawyer might promise the party, you will have to pay, let's say, 200,000 for my fees, and if I am successful, it's going to be another 50% to it. The question is, the 50%, is this something which they can claim from the other side? Some jurisdictions, such as Singapore, say that you cannot make the losing party pay the uplift of the 50%. Some jurisdictions do allow them, such as Hong Kong, leaving to the discretion of the tribunal. So for a tribunal who is being asked to decide whether the uplift fees should be borne by the losing party, we should look up for these issues. Moving on to interest. Interest can be awarded on damages or on costs. The interest rate to be applied would usually, even in the situations of international commercial arbitration, we usually follow the local statutory interest rate in the law of the seat. Time when interest begins to run, the default rule or the common rule would be from the time of the award. But if the damage that has been pleaded relates to events that happened prior to the award, and there's a good reason that interest should start to run from a particular event of breach or whatever event it is, then the interest rate should run at an earlier time. And of course, interest would usually apply up until the date of payment. Here you can see I've put in a box the reasoning portion in relation to interest. So sets out very briefly what the payment submissions are as in relation to interest rates, the respondent's submissions, and the tribunal's reasoning as to why it should be following the law of the seat. Next slide, please. So my last slide in relation to interest. I've covered very broadly general interest, the appropriate rate up until the date of payment, and perhaps again, sometimes an adjustment required for multiple currencies. The golden rule is interest is meant to compensate the payment, not penalize the respondent. That's why the local statutory interest rate would usually be preference. Pre-award interest rate, I've covered that earlier, but again, I think the short point is that it's less frequently applied. Compound interest, in my mind, makes sense only if factually the unpaid party did suffer the loss in relation to the compound interest, and so you then do it at monthly or 3 monthly US. And the last point, of course, if interest is forbidden under the laws of the seat or in any other jurisdictions in which the award might be enforced, then it's something which you obviously would not be able to do in the law. Thank you.
Thank you so much, Susan. Just a short point here, a lot of the domestic arbitrations and in fact arbitrations seated in India sometimes do not accept or rather they don't have the practice of accepting cost submissions or submissions on cost. So when you are sitting as an arbitrator in India, like Eugene said, you may benefit from the cost submissions submitted by parties. So it's you can keep that in your mind when you are drafting the first procedural order and actually have that as a stage at the beginning of the arbitration. It will really help in the cost section of the award. May I now invite Shruti and Dia, please, to take us to the last segment of this training, which is very interesting. It's an exercise about the dispositive sections, and I will do it.
Now we'll check if you really listening to what is being said. very subjective. There's no right and wrong really. So
There is right and wrong.
I'm trying to ease it. Okay, fine, there's right and wrong. So what we've done is we put together, a few examples of the dispositive sections. We're going to bring them up for your consideration, and then we'd like to hear from you any issues that you can find in this.
I mean, when we say the dispositive section, that's sort of the last part of the award, which says X has been awarded, Y has been awarded. And to just start off, before you look at it, the idea is that it should be very clear and concise. There should be no ambiguity whatsoever in what is the direction that the tribunal is giving. So what our exercise has done is it's created perhaps some with ambiguities and some without, and we'd like you to point out where you feel it should be better drafted.
So this is a dispute between Alpha, who is the claimant, Alpha Engineering Limited, and Beta Trading Private Limited, which is the respondent under the supply agreement. Alpha Engineering Limited seeks a payment of 500,000 USD for goods that it delivered to Beta. And the respondent, which is Beta Traders, argues that the goods were defective and it seeks counterclaims, essentially damages, for $200,000. The dispositive section is on the screen before you. The tribunal thinks.
So the way it's been drafted, and we'd like you to tell us how we perhaps could redraft it, if at all, or if it's fine. The tribunal thinks Alpha should win. So Beta is to pay Alpha 500,000, which should be done for Beta. Beta's claim for compensation about the bad quality of the goods is rejected, since we don't think they proved it very well. Cost will be decided later, maybe depending on what happens if Beta pays or not. So anybody, hands up.
My name is Sushil Shankar. So if you look at the dispositive part, probably an intern in a good law firm also would probably draft something better than this. So the tribunal thinks, so the word thinks is again subjective. No reasons given. So that's one thing I can say. Which should be done quickly. Quickly is also not very clear. It's a sort of wait, a date or a time period before which it should be done for a reason. What is quickly is matter of interpretation. Where is that? Yeah, I'm sorry. Yeah, 500,000 what? Euros, dollars, whatever. The currency convention. Since it's rejected, since we don't think, again the word think, they proved it very well. That also could have been worded much better. The manner in which it was proved. And costs will be decided later. Maybe, the word maybe again. Maybe depending on what happens with Beta pays or not. Like I said, very badly drafted.
Okay, will somebody else just take a crack at drafting that first part then?
Go ahead.
Not a definitive order itself. Tribunal think it should be done.
Yeah.
Not a definitive.
Absolutely.
Actually, it's not a finding. It should be a finding because that it will not be binding actually. So there is no finding, no binding. And there is no
For later.
for payment also there is no timeline given. So for better enforceability there should be timelines.
Absolutely.
Yes.
Given it's a dispositive, all it means to really say is the tribunal orders that Beta will pay Alpha $500,000 on forthcoming date, and the claims of Alpha, the claims of Beta are dismissed. That's really the only two things that are needed.
Absolutely.
And as far as cost, if there's an order, it will say costs are awarded. If costs are being deferred, then it will have to say award, save certain costs.
And of course, not deciding the cost, I mean, that's such an odd thing for the dispositive to say, it depends, and we'll see, maybe subsequent. But the moment the final award is come, the tribunal is functus officio. So there's no question of it deciding anything, later on that.
Just one quick point. The very first sentence, there's a problem. It's a conclusion. And there are no, how do you come to that conclusion? There is no discussion on that. So this is basic jurisprudence that anything, a a conclusion cannot come first and cannot follow by narrow reasons here.
So this is the dispositive part of the award. Like we discussed, the award is broken up into various parts. The conclusions, the reasoning will come in a different part of the award. This is the sort of final. It's almost like you're pleading what you call your prayer clause, right? So these are the prayers that have been granted. So it's called the dispositive part of the award.
But a fair point still, I mean, basically, it could at least say because that.
For the reasons stated above, or
all the
reasons
reasons here. Since we have already
discussion.
found the breaches by beta against alpha, something.
And definitely the ambiguity part is.
Yes.
One more thing, it should be in serial number, like different heads dealing with difference 1, 2, 3 or A, B, C, D for better understanding for 34 codes.
Yeah.
Or 37 whatever.
Yeah, that's a great comment. Okay, yes.
Silent about the interest.
Silent about the interest, yes.
Not clear, the ambiguity is there. And likewise, it's not that in standard language to mean this positive part. As what we have said prior. Thank you.
Maybe we now move to the next example.
So I'll just read this out. It says Gamma Solutions Private Limited terminated Delta. So Gamma is the employer and Gamma terminated Delta, the employee, who is the claimant, a senior project manager alleging gross misconduct for unauthorized data transfer. The employee seeks 1, a declaration that the termination was wrongful, 2, payment in lieu of 6 months notice of a contract, 3, unpaid bonus for the prior fiscal year, and 4, compensation for reputational harm. The employer counterclaims for liquidated damages under a non-solicit clause, alleging the employee solicited a key client post-termination. And this is our dispositive. Since we think the firing wasn't handled properly, Gamma must undo its breach and what it did and give Delta all that is due to him/her, including 6 months' money and the bonus for the previous fiscal year, which is 1.2 crores approximately. Of course, interest will have to be paid by Gamma on these sums. 2, as for Gamma's complaint about the breach of the non-solicit clause, that's not convincing, so everyone should pay their own legal costs. Volunteers.
Once again, the formation of the dispositive part is not clear because it's a long sentence. Usually, whatever you just stated, that should be clear and short sentence. And again, the currency is not given. Of course, interest will be, there is no finding or there is no basis clear. So it's a vague thing.
Anyone else?
Please go ahead.
I'll just focus on the second part of the dispositive part. And presuming that there are more than one party on the respondent side, where it says that everyone should pay their own legal costs. That is something which is not true.
Also, the amount that is there is within approx. The interest usually calculated on the definitive amount. So you have to be very definitive on the amount. That's what you know.
So the second part, which deals with range of non-solicitation laws and legal costs, I think they are unrelated. Both parts of that sentence are unrelated to each other because one is the first part deals with the counterclaims which she has not addressed, and second part deals with legal costs which both parties may be. These two have to be separately addressed by the arbitrator, not like this, because they are not connected to each other at all.
Absolutely. Yes.
In fact, the rate of interest is not mentioned in the first part. So rate of interest has to be clear, whether it's simple interest and what's the rate of interest, whether it will be compound interest, from which date it will start and which date it will end. Secondly, the approximate word used along with the figure 1.2 crores, that is also a vague amount. Once you have all the details and how much salary would required to be paid, the amount, once it's a final award, amount has to be certain that how much amount needs to be paid by either of the parties. So the first part of this dispositive part is also quite vague.
I think there is no rare for interest also. Claim is not there for interest.
And can interest be awarded if there is no claim, or that's a separate matter?
Paid by the
previous speaker, the tribunal should restrict itself to what is there, not go beyond.
Yes.
I mean, apart from the structuring, etc., I think there's also a contradiction when it says Kama must undo its speech and what it did. Now, one of the first things they did was the termination. And then it goes on to say, including 6 months money, which is in lieu of the 6 month notice of the contract. It's not very clear if they want the person reinstated.
That's right.
If there is a reinstatement, from what date? And if there is a reinstatement, would you still get the 6 months money?
So is it a specific performance direction or is it a compensation direction?
Exactly.
And there's a
So there is an ambiguity. And ideally, the best way to deal with something like this, where you have 4 claims, 1 counter claim, and then of course cost interest, is to just break them down and one by one just knock them off, saying yes, no, in straight sentences.
And isn't it odd that they find very clearly breach and if they find for one party but legal costs, everyone must bear their own. Why should everyone bear their own legal costs?
You see that in our
Yes, why should we bear our own legal costs?
Conclusion for our speaker, I can say that life of uncertainty is killing the certainty of the relief in dispositive party.
And the counterclaim has to be clearly certain. There's no mention of counterclaim.
I believe the words that we, when we draft the operative portion of the award is very important. So here we see, in the first part itself, the use of word think, Gamma must undo its breach, then the use of word of course interest will have to be paid. The use of these words is not correct. Absolutely. The operative portion should be very careful.
And also just on that same sentence, right, all that is due to him or her, including 6 months and bonus, which is approximately 1.2. So what else is therefore being awarded as a consequence of this?
Move on to our last example.
So Vega Infrastructure Limited, the claimant, and Atlas Ports, the respondent, entered into a long-term non-construction contract with liquidated damages clause for delay and a cap on liability excluding loss of profit except for certain milestones. Disputes arose between unpaid milestone invoices totaling so-and-so, Atlas's deduction of liquidated damages for 45 days of delay, Vega's claim for lost profits on a cancelled expansion phase allegedly triggered by Atlas's breach. The tribunal has jurisdiction under ICC rules, seat in Mumbai, Indian governing law. Both parties requested declarations on liability allocation and interpretation on the LD clause and liability cap.
So this is how we drafted the dispositive. 1. Given everything discussed above and the commercial realities, Atlas should clear the pending invoices while keeping its rights under contract intact, but neither side should treat this as a ruling on liability because the parties may still negotiate later as they see fit, and this award records that understanding. 2. On the LD and cap issues, we think the contract should be read in a business-like way, so liquidated damages can be adjusted if more facts come in. Also, both parties' broader claims are reserved so that any court or a future tribunal may sort them out as appropriate without being constrained by this decision. Anybody?
There's no finality to the dispositive part involved. It's all open-ended and it's not subject to whatever may happen in future. And that's not the intent of passing it.
Absolutely.
It seems they're referring to the mediation.
Potentially. It seems like parties have come to some sort of an arrangement that is also recorded here.
Can I see, this is the last example, right?
Yes.
Can I say something about these three? It's an interesting observation, but sitting next to me. As badly as these dispositive parts might have been written, they are by themselves not reasons to be to set aside the award. it can call for clarifications, and many of these can be clarified. So you might not be able to set them aside just on these grounds.
I mean, the idea is really at this point we're looking at how we should draft an award as arbitrators.
I got that point. I mean, this just for
But you're right. I mean, this would be something you could perhaps go back to the arbitrator to clarify.
Yeah.
But at the same time, it could also, lead to a situation of ambiguity in the award.
Unless you're a losing party in any of these awards, of course, then you won't ask for the clarification and you go straight to court.
Thank you. Thank you. I think this was lovely, and in fact, we did have 2-3 others prepared, but we are mindful of the time. Thank you so very much, our speakers. I now open the floor for brief questions. We have time for 2, maximum 3. Yes, the gentleman right here was very, very quick, so we'll take a question from you. And please also, if you can specify who the question is addressed to, that would be lovely.
Hello, I'm Aditya. I'm a Delos and I'm also an independent arbitrator. So my question is to Ms. Kapoor and Ms. Light for both domestic and international perspectives. Ms. Kapoor discussed the recent DMRC judgment. So after that judgment, what is the relevance of Section 19 in the Indian Arbitration Act? In the sense that if the arbitrator does not get to choose what is vital evidence for that particular case and decide accordingly, and all the rules of evidence as per the evidence have to be applied in that manner only, then what's the elbow space left for the arbitrator? And like Mr. Election pointed out, that while drawing adverse inference, a person has to be careful while reducing the weight attached to it. So, especially in the context of Indian arbitration, or if one of the parties is released, how do we go about it as arbitrators while discussing it in our decision? That is my question.
So, I mean, DMRC is has come under a lot of criticism for a variety of reasons. But I think this particular part about vital evidence, I mean, of course, as arbitrators, we don't need to look at all pieces of evidence. But I think when you are ignoring vital evidence, your award can come under challenge. So, which is why when we said we're looking at the reasons, by going to the reasons of the award and reasoning of the award, there will always be certain vital arguments and certain vital pieces of evidence. I mean, you don't have to deal with the entire kitchen sink of arguments, the entire kitchen sink of evidence, and so on, but there will be certain key arguments and key pieces of evidence. Deal with them in your report. The court may agree or disagree with your conclusion, but if you at least dealt with it, the allegation cannot be that you will ignore vital pieces of evidence.
For example, if I decide, there are 5 documents. If I say that these 2 documents are clinching pieces of evidence, and hence the remaining 3 are not best, is not best evidence according to me, and hence I am not relying upon it. Would that be sufficient reasoning as per DMRC, or the court can substitute this reason that that was also vital, and you ignore that point?
I mean, in my view, that's sufficient reasoning. Stop that.
Did you have something to add? Fantastic.
I have a Delos specific question.
Delos question. Specific. Yeah, then Hafiz, please. That's the mic there to the gentleman, please.
I'm going to use the word sanctions in 2 senses, 2 very different senses. So you have sanctions by the arbitrator for a party misbehaving and things like that. So what is Delos's position on that? And then international sanctions nowadays, because I'm sure you're dealing with a lot of international cases also, countries imposing sanctions and then awards not being able to be enforced after that. How are you dealing with it? Because one man's sanction is another man's,
Interesting questions. On the first point, it is not the role of the institution to police the parties in a proceeding, but to provide a framework that empowers the tribunal to conduct the proceedings in a way that safeguards the process. So if there is a need to get the parties back on track, it is part of the powers of the tribunal to do so. Where we are more explicit in our rules, is in instances, for example, where the parties may create conflicts of interest with tribunal judges. Otherwise, what we've done is we've given the tribunal, so arbitrator or three-member panel, we've given them the powers they need to be able to address party misconduct or other tactics. On the question of sanctioned parties or sanctions more generally, so there are a few points to consider, and I don't want to spend too much time on this because it's slightly outside of our topic, but clearly we're going to run careful KYCs. We're going to be careful about where payments are coming from. We're going to be very careful that we are not as an institution reaching sanctioned legislation. And then we're also not locking parties into something that just creates more issues. So we'll do our homework, and then we'll reflect that homework in a cautious manner. There are too many scenarios to go through in abstract, so it's difficult for me to give you a specific answer, but hopefully that addresses.
Thank you. Thank you, Office. We have time for one last question. If there is one, your gentleman in front, please.
There are two questions actually. One is a follow-up from that gentleman. Like for taking payment, is there any check or any declaration you take from your website for payment? So, like you mentioned that KYC, like to avoid that anti-money laundering laws and to fulfill the sanctions requirements. Is there any checks or any declaration?
So I'll distinguish three types of payments. First is the filing fee, which is fairly straightforward, and the point there is to allow parties as easily as possible to commence the arbitration. And by that I mean trigger time limitation. So that is fairly open on the basis that the amount is a very small one. The idea is to make it as easy as possible, and then we will come. Second type of payment, when parties are paying advances on fees for the institution of the tribunal. They will be very attentive, and what's already happened is where we've got questions or where we want to be very cautious, we will ask parties to fill out detailed forms about the source of funds. The third scenario is where parties are asking the institution to hold funds for them. We'll be particularly careful about that as well. And nearly systematically, we will be asking for information on the source of funds so that we're not complicit of any potential laundering.
Thank you, Arthur. This discussion has really steered away from a voluntary, but I'm glad that we touched upon those dark areas as well. Thank you so very much. Sorry,
one more question. Like everyone mentioned that the award should be short and brief and crisp. Sometimes, in your experience, there are complex matters where there is a longish award, and there are lots of evidences we knew which the tribunal feels that it should be referred within the award. So what should be the best mode? Should be annexure based, or should be the evidence should be referred as a footnotes? In your experience, what should be the best way?
So here we're referring to experience, and I think all of us around this table virtual table would have their own comments to make. As an arbitrator, I would distinguish three scenarios. One is the issues in dispute, which I'm going to try and address in a manner that is clear, articulate, comprehensive as possible for the parties. The second scenario is where parties have argued extensively around the point, which is not directly relevant to the outcome of the war, which becomes moot because of the issues, because of the way I dealt with the issues. At that point, I may flag the fact that I'm going to address this in a brief manner, only because the parties have expended so much effort on it, and in this situation where I get the sense that it is important for them to get an answer to that, but I'll be very careful with the word to make clear it's an overturn. This is just to address, in response to the efforts the parties have made, and no line to be placed on it. The third, and this goes back to some of the things that we've been discussing, is sometimes, especially in a, let's say maybe English style of drafting, you'd be tempted to throw in your own thoughts, your own comments. Be careful about that. Ultimately, is that relevant to the war? Is that relevant to the outcome? So if you're going to go beyond, you need to really ask yourself, what purpose are you achieving? And are you not, in doing so, adding characterizations, for example, of bad faith of one of the parties, which may not be necessary, especially in the context of, for example, the parties being in a long-term commercial relationship. Got to think beyond your words. Sorry, I hope that was
Thank you so much. You were quite long, but I didn't want to. But anyways, we are wrapping up. I think our session was really, really interesting. We could have gone on for longer, but we do have a hard stop. I have 5 key takeaways which I noticed when the speakers were speaking. I think what we've learned is enforceability is non-negotiable. What you really need to think about is reasoning, because that's the bridge between parties' arguments and the dispositive section. Who you're writing for, the audience really matters. Avoid common pitfalls. Thank you. Avoid common pitfalls, which is unclear findings. We've seen that in our guided, discussion, and continuous improvement. Because what I think may be an enforceable award today, this is my jurisdiction, may not be the case, maybe 2 years down the line, when there are judgments that are updated and new laws come up. So I think that's where we all are in terms of this particular session. I am really, really thankful to all of you for taking out the time, and of course to my distinguished panelists, thank you so very much. All of you were amazing. A huge round of applause. We have just ended the first session of the Delhi Arbitration Weekend today, and I'm hoping to see all of you in the coming days. In terms of the Delos route access agreement, I would say that forward, you will all get an email with certain materials that have been prepared basis this training as a follow-up material due to the rules and other materials packaged for you. Delos does run a certified arbitrator program as well, which you can enroll for. I believe that the next session is already full, but they're open for the next session, for the sessions thereafter or next year. So please do log in and check that out. And I hope to see all of you soon during the course of the next few days. And thank you so very much. Thanks to the panel, which is all women's panel. If I exclude you, this would just be women. But yes, I'm so very happy about this panel and so very proud. And thanks so much to everybody. If you could just stand here and have a little picture, I would be great. Thank you so much.